All persons having business with the appellate are near to the attendant and shall be heard. Please be seated.
Welcome to the Appellate Division First Department. We have over 4.5 hours of argument time requested, so please ask for the time that you need, not the time you want. We are familiar with the briefs and the records, and we will keep asking questions if we have any. People versus Taylor is submitted. Marie versus France is submitted. J.A. versus Mandy Associates, appellant. Respondent? 6, 1, and 6. Krogan versus Adams, appellant. Respondent? 6 and 5. Kenneth versus Miles Gustav is submitted. People versus Huggins, appellant. Respondent? 6, 2, and 6. Wallach versus New York City Health and Hospitals, appellant.
Request 7 and 2, Your Honor.
Respondent? 7, 1, and 6. People versus Tyrone is submitted. Thorograph versus New York Racing Association, appellant.
Request 6 and 1.
Respondent?
Respondents request 6 minutes, Your Honor.
6, 1, and 6. YC versus City of New York, appellant.
Appellant request 7 and 2, Your Honor. Respondent request 5 minutes, Your Honor.
6, 1, and 5. Success Academy versus Liberty Square Realty, appellant.
Appellant request 6 and 3.
Respondent?
6 minutes, Your Honor.
6, 2, and 6. Gigowsky versus Mount Sinai, appellant. Yes, no, I'm aware of that. Respondent? Appellant?
Also the cross appellant, and I'd like 6 and 2 would be fine.
I mean, I'm going to give you each 6 and 1, and again, if we have more questions, we'll keep asking. What? Oh, I skipped a case. Kirby versus David Fabricators. Sorry about that. Not because I don't care about the case.
Appellant request 6 and 1, Your Honor.
Respondent? 6, 1, and 6. And Gigowsky versus New York City Board of Education is submitted. So our first case today will be J.A. versus Mandy. Go ahead.
Thank you, Your Honor. May it please the court, Reuven Frankel for the plaintiff's appellants. The motion court should have granted
My
some.
first question for you is, how do you pronounce heme? Do you pronounce it heme? Okay, so my first question for you is about heme.
Sure.
Why should heme be considered an actionable injury in the absence of any other injury as a result of the heme?
2 primary reasons, Your Honor. Number 1, under the Court of Appeals case in Coronia v. Philip Morris, and subsequently in the Benoit case, the Second Circuit's interpretation of Coronia, applying New York law, a physical injury in the toxic tort setting is shown when a plaintiff shows a clinically demonstrable presence of a toxin in the blood or some physical manifestation of the toxin. Heme, under that test, would check both boxes.
I'm sorry, I didn't read Coronia as really stating that holding. Didn't Coronia say that you have to have some physical injury?
Well, the question in Coronia was a certified question of whether you could have a medical monitoring claim in the absence of a physical injury, which
But that's not what's at issue in our case, a medical monitoring claim.
it is not. But
So putting aside medical monitoring, which is a different issue, didn't Coronia actually hold that you have to have evidence of a present physical injury
Yes.
to have a claim in tort? So doesn't that actually support that heme isn't enough? Because heme doesn't necessarily produce any injury just by having heme, elevated heme.
But in Coronia, it defines what a physical injury would be in a toxic tort case, and they adopt the second department's holding in abusio, in which they say,
What about Bygrave, which is the first department, that a plaintiff has to prove that he or she developed physical symptoms as a result of having been exposed to lead paint?
on Bygrave, there's two things. First of all, Bygrave was not concerned, heme was not an issue in Bygrave. This court does have precedent specific to heme, and that is Vega v. SSA Properties and Veloz. In Vega, this court reinstated the plaintiff's complaint, and
But didn't the plaintiff in that case also have other injuries besides the heme?
it did, but heme was the entire thrust of that opinion. If
Well, let me ask you, if heme was enough of an injury in it itself, why didn't the court in that case grant summary judgment to the plaintiff?
It reinstated it because there was competing evidence.
But there was no dispute that the plaintiff in that case had elevated levels of heme, right?
That's what my friend argues, but there's no evidence of that in the opinion.
Well, isn't heme something, I mean, that's part of what I'm thinking about, because heme is not, there's no dispute whether or not a plaintiff has elevated levels of heme, right? Either you do or you don't. So if heme was an actionable injury, wouldn't that be it for the end of the analysis?
Heme and an elevated blood level are not the same thing, Your Honor.
I'm saying elevated levels of heme. If elevated levels of heme were enough by itself, then the plaintiff in that case should have gotten summary judgment.
No, Your Honor, because in that case, there was competing evidence from the other side, and this court referenced the competing evidence between the two experts. My opponent...
Competing evidence would have had to do with the manifestation of that, not necessarily the, as my colleague has pointed out, the elevated heme alone.
There was competing evidence. They had an expert in which in which that was challenged, and
Does it challenge the basic fact of whether or not, because that's what I'm trying to get at. Heme, you either have elevated levels of heme or you don't. That's not really something an expert could challenge, is it?
And well, it depends, and that's what I was trying to get at. There's two separate things. You could have medical records showing elevated blood levels. That's
a different issue.
That's a separate thing.
We're talking about elevated levels of heme.
In Vega, there weren't lab records showing elevations of heme as there is in this case. In this case, we have objective evidence of heme elevation.
Why, putting aside the precedent, because none of the precedent is as clear as it possibly could be, putting aside any precedent, why should elevated levels of heme by itself be an actionable injury under our law?
Because heme is evidence that there's been a change in the body. There's been a response, a physical response to the toxin that's been introduced into the body. And in this case, by the defendant's own expert's testimony, that manifested itself as iron deficient anemia, which even according to the defendant would be...
Right, but you didn't bring up anemia till the reply papers, and you never refuted their showing that anemia is totally reversible. So are you hanging your hat on anemia as the injury?
Anemia is a manifestation of heme. That's a known thing. If you look at the Department of Health records...
I'm sorry, is heme a positive thing or a negative thing?
Heme inhibition, which is what...
Heme inhibition, right. So it's a deficiency of the heme.
It's a deficiency of heme.
Okay.
Heme inhibition. The lead causes an inability in the body to produce heme, which the body is dependent on for the circulation of oxygen throughout the entire body.
And so what evidence do we have here that the circulation of oxygen to the body was impeded or there was a manifestation of such an impediment?
Two things. You have elevated ZPP levels, which shows a decrease in heme, and that's at 216 and 217 in the Montefiore records. And it's referenced at 198 in the Department of Health records. And that shows that, and the response to that, the physical manifestation to that is the anemia. And that's referenced in the Montefiore records, which I'm talking about. The child was actually treated for it with iron supplementation.
Okay, I'm going to let you have time to reply.
May it please the court, Brian Ginsberg for Mandy Associates. Plaintiff's motion...
Let me ask you the opposite question. Why isn't heme inhibition enough to establish an actionable injury?
It's not enough standing alone to establish an actual injury because it does not carry with it, at least on the facts of this case, the undisputed testimony, which is what plaintiff would have to show in order to get summary judgment, any here and now physical symptoms.
What about the fact that it has altered, the chemistry of the body is altered as a result of the ingestion of the lead? Why shouldn't that be considered enough?
Well, the Court of Appeals, I'd have to go back to the Coronia case and previous cases. I know you asked for an answer based on first principles, but I do think the precedent here is also.
No, I wanted both.
Yeah.
And your colleague supported Coronia, so I'm curious, you're both citing to it to support your argument, but go ahead.
That's right. So in our view, Coronia is exactly on point for our point of view, that plaintiffs alleged in that case that throughout years of smoking, they had ingested cigarette tar, causing, quote, subcellular injury and damage to the structure of their lungs, but they had not yet begun to manifest physical symptoms. The Court of Appeals found, among other things, that that was insufficient to show the requisite physical injury that you need in order to maintain a tort claim. And that
You're saying the heme inhibition is like the same thing as the smoking, that till there's some injury manifested in the body, that's insufficient to establish tort injury.
It's similar in that way, Your Honor, because here with heme inhibition, again, divorced from other symptoms which have not been established as a matter of law, heme inhibition itself is a subcellular or a cellular change, just like the subcellular change that the plaintiffs alleged in Coronia, but that's it. There's no manifestation of here and now physical symptoms.
Is there any consideration to be given to plaintiffs' experts' assertions about these physical manifestations?
Well, about the
I guess in comparison to your expert, because then we have competing experts, which is what your adversary was indicating. In the other cases, we had competing expert testimony.
Well, we've got competing expert testimony here, Your Honor, because my friend on the other side does say that because of lead exposure, in addition to or perhaps through heme inhibition, certain other injuries were caused, brain damage, deficits to cognitive function, et cetera. Our experts refute that. Our experts say that those injuries either were not present at all on their own examination of the infant plaintiff, or to the extent
doesn't your expert say that lead exposure commonly produces anemia by inhibiting heme synthesis, particularly in children?
Yes, he did say that as a general matter, and if
So in this case, there is the allegation of the anemia, so why is that not an injury?
Well, first of all, you don't even get to the opposition papers in a summary judgment motion unless the movement has proven a prima facie case, and there is no prima facie case made here about anemia. That's one of the problems with the anemia argument.
Let's assume that there is.
Okay.
Then what would be your response?
If there was a prima facie case made about anemia, I think my first response would be, because this argument was made at the first time in the reply brief stage on appeal, that I would appreciate if the court would order supplemental briefing on that, because we have not had the chance to respond to the anemia allegation or argument in a brief, raised as it was for the first.
So if I'm understanding you correctly, then your response then with the anemia is that they brought it up too late, and so you would need time to respond as to whether that is an actionable injury.
Well, there are layers to our responses, Your Honor, and I think we got into this a little bit in our motion. Number one, as a matter of appellate consideration, it was raised too late, first time in the reply brief.
Well, I'm going to grant you that just for the sake of this discussion, because really the answer that I want is, had it been done properly, would the anemia be sufficient?
I guess I'm not sure, Your Honor. I don't know what our brief would look like, but I understand.
That's not the question before us, according to you.
Exactly right, Your Honor. And to the extent there is any skepticism about anemia and some sort of manifestation of physical injury, I do want to be heard on the issue of remedy before I sit down.
Also, before you go into that, I have a question on heme again. You said that it's a manifestation of some cellular change. Is that cellular change reversible?
Is heme inhibition reversible? It's my understanding that it's reversible simply by taking iron supplements. But regardless, even if it was not reversible, which I think the record shows that it's readily reversible, still there's no manifestation of a here and now physical symptom that would satisfy the court's physical injury requirement, which predates Coronia. I mean,
The only way you can have a physical injury is if you have sequelae.
the only way you can have a physical injury is if you have, I don't mean to quarrel too much with that, Your Honor, but the only way you can have a physical injury is if you have some sort of manifestation of a here and now physical symptom. That's what Coronia stands for. To the extent the Second Circuit interpreted Coronia differently, A, that's not binding on this court. B, the Second Circuit was doing a fundamentally different job than this court was doing. Federal court's job when trying to predict state law is trying to figure out what the Court of Appeals would do if the situation were put to the Court of Appeals. This court's role in applying Court of Appeals precedent, of course, is to figure out what the Court of Appeals did do and did hold. Your Honor, I see my red light is on. I do want to be heard for just 30 seconds on remedy in case the court gets there. Even accepting the notion, which we don't accept, that inhibition of heme is an actual injury, or even if you get to the anemia issue, which we don't think is properly before this court, still the remedy would not be grant of the summary judgment motion and remittal for only a trial on damages. The only thing that would have been established, taking Your Honor's points on anemia, would be causation of anemia itself standing alone, or of heme inhibition itself standing alone. So the plaintiff would still
You mean
need to
whether the lead paint caused the anemia or the heme inhibition?
Yes, exactly. That would be established if
And you
we're...
didn't have a chance to address whether or not in this particular case the anemia was caused by the lead paint because it came up in reply.
Well, there's that, but I'm also making a broader point that there are a number of other injuries that my friend on the other side asserts, in addition to heme inhibition and in addition to anemia, such as brain damage, abdominal pain, headaches, and the like. Whatever the result of the disposition of my friend's argument about...
There would still have to be a trial as to the other issues because they're not getting resolved here.
As to causation, not just as to damages, but as to causation as well. That's
Okay,
exactly
thank you.
right, Your Honor.
Thank you.
Thank you, Your Honor.
Justice Higgett, just to get to your question, heme is actually a sequela of lead poison. Anemia is a sequela of heme. So heme already is sequela of lead poisoning, and to that point, lead poisoning itself, under Juarez v. Wavecrest, the Court of Appeals, the seminal case on this issue, lead poisoning itself is an actionable injury, because in Juarez, the only proof in the record that existed was evidence of elevated blood levels. Plaintiff did not have an expert in that case. And so that case, and this Court of Appeals granted summary judgment on the issue of causation there. So that clear that lead poisoning itself is an actionable injury, and certainly heme inhibition is.
If we agree with you here that heme inhibition by itself, because the manifestations, most of the manifestations were addressed by your friend's expert, and so there's a causation issue there. But heme inhibition in and of itself, if we accept your argument that that is a physical injury for New York tort law, do we run the risk of undermining Coronia's warning that we don't want to open the floodgates for unfounded claims and frivolous claims?
No, Your Honor, because that, and it kind of goes to my friend's comments about remedy, that all goes to the extent of damages. All that we have to show on a motion for summary judgment is that an injury occurred. And when it comes to heme inhibition, I would urge the court, Vega not only discusses heme inhibition, but Vega cites Campbell, which is a Second Circuit case, for a, quote, extensive discussion on lead poisoning. The only thing discussed in Campbell is heme inhibition.
Thank you.
Cynthia, can I have one more? I have one more question for you. Let's assume, again, we agree with you. We grant summary judgment in your favor on heme inhibition. Would that make for an unwieldy or unduly complicated trial for the finder of fact, given that we will have taken heme inhibition out of the equation and left all of those various physical manifestations and the related causation questions for the finder of fact?
Your Honor, it's the same exact thing. The analogy would be in a simple negligence action where there's an uncontested injury, but lots of other contested injury, an uncontested broken wrist and a contested brain injury. Liability has been established. That's the determination here. Everything else goes to a trial on the extent of damages. And I agree with my friend. There would be competing evidence as to everything else, and we would have the burden to prove that the child suffered all those injuries, and that would go to the finder of fact. That's why we have damages trials.
Thank you. Krogan versus Adams.
Your Honor, I neglected to reserve a minute in rebuttal. May I have that?
Well, then I'll take time off your main case, 5-1.
All right. My name is Leonard Schreier. I'm General Counsel of the Organization of Staff Analysts, which is the union in this proceeding, which was brought on behalf of 13 individual petitioners who had served in the physically taxing title of supervising traffic device maintainer.
Let me ask a specific question, because this is sort of a granular case. If SSM levels 1 and 2 were not deemed to be physically taxing before the reclassification happened, and they were not on the official list before the reclassification, why would the reclassification affect anything, particularly when the DCAS resolution was explicit that there would be no change in duties or status for this reclassification? So nothing really changed. So why would it change?
Well, in fact, although the DCAS resolution does speak to no change, if you look at the job description for the STDM level 2 and 3, it is substantially different from the SSM title, which OSA represented and which we had understood at the time we represented them, that it was a non-physically taxing title. However, this was a broad band of a physically taxing title, the 90904 STDM title, and the new job description specifically says that in addition to all the duties of an STDM level 1, the former SSMs, which are now STDM level 2 or level 3, would perform their supervisory functions. But the broadbanding, in fact, was a broadbanding to permit them to do the physically taxing actions that are set forth in the job description.
This is a arbitrary and capricious standard. It's in Article 78. It's not. We're not deciding as a matter of first impression. Why was it arbitrary and capricious for the decision to be based on the specific DCS resolution, that there wasn't any change?
Well, there is a substantial change. If you look at the job description, it talks about the physically taxing work of the STDM level 1, which is now being performed by the levels 2 and 3 in addition to their supervisory functions. I think what's important to remember here too is that the pension system had changed it as of April 2012 with the introduction of Tier 6, so that there was no longer a physically taxing early retirement. And so the STDMs, who are now the subject of the action, are among the last of the employees who are in fact benefiting by their right under Tier 4 to be in a physically taxing early retirement
What significance does that have for the analysis?
I'm sorry?
What significance does that fact have for the analysis?
Well, because the new proceeding, I think, was actually developed so that they could expand, the city could expand the physically taxing role of the title. They would no longer have to pay the benefits to those employees and permit them to have the early retirement. April 2012 was when the new pension system, Tier 6, went into effect. And so you could have people performing physically taxing work and just have the ordinary retirement benefit, which all other employees of the city would be able to apply for. Before that, you did have that special 2055 proceeding, which permitted people to retire early. And so by expanding the physically taxing role, the city at essentially no cost would be able to have people do the physically taxing work and still have employees working till age 62. without the benefit of the early retirement option. It's only these employees for whom we brought this proceeding who were in Tier 4, were not told when they applied for Level 2 or Level 3 positions. They were STDM 1s. No dispute that they were performing physically taxing work. When they accepted a promotion to the higher title, they didn't know that the title would no longer be considered physically taxing. The job description is a physically taxing job description.
Were these jobs on the
Title code
official
is the
list?
same. Excuse me?
Were these new classifications on the official list?
I'm sorry.
Were these new positions on the official list?
The new positions are in fact on the official list because the official list is 90904, which is the title code for the new positions. The only use of the 9090A was on the payroll. And if
Thank
you
you.
look at the evidence.
You have time for rebuttal. Thank you.
Good afternoon. Good afternoon, Your Honors. May it please the Court. Amy McCampbell on behalf of the City Respondents. Your Honors, this Court should affirm the denial of the Article 78 petition. Petitioners challenged the purported removal of their job titles from the official list of physically taxing positions, but those job titles were never on the official list in the first place, so they were never removed from the official
Can
list.
you respond to the question I just asked? When the reclassification happened, did those positions get on the official list?
I'm sorry, Your Honor, can you say?
When the reclassification happened, did the new positions that were created become part of the official list?
The new positions were just the SSM position reclassified, and the SSM position was never on the official list. Petitioners agree with that. Petitioners.
What about what your adversary raises about the STM1, the physically taxing portion of that now being done by the 2s and 3s?
Sure, Your Honor. So a couple of points in response to that. So the new job descriptions do mention that the STDM 2 and 3 may occasionally do the jobs of STDM level 1, but that, to the extent that they're arguing that that entitles them to the physically taxing benefit, it does not. The position has to be on the physically taxing list. Now, their union can bring a proceeding with the Board of Collective Bargaining to add a title to the list. They've never done that. These jobs, even if they might occasionally do STDM level 1 work as mentioned in the job description, they're not on the officially taxing list. And again, there's avenues for them to pursue if they think they should be on the list, but they never pursued those.
The adversary mentioned something about the payroll code. What importance does that have here?
So if you look at the officially taxing list, all the job titles on there have payroll codes. And the payroll code for STDM is 90904, and that's on the official list. STDM levels 2 and 3, which were created in the reclassification in 2012, they have job title code 909A, which is not on the official taxing list. So it's very, very clear that you can look at the official taxing list and see that the job title code on your payroll, if you are pay stub, if you are a STDM level 2 or 3, does not match up with what's on the official list because these jobs, again, were reclassified and were never on the officially taxed.
But your official list doesn't say what level the STDM is. It only lists STDM and it gives a code 90904. It doesn't say level 1, 2, or 3.
That's
so
right.
How are we to know that you don't mean all 3 levels when you mentioned this on your official list?
So 2 points in response to that, Your Honor. The reason why it doesn't list the levels, as our affiant explained in the Article 78 proceeding, the official list was last updated in 1995 before there were the sub-levels. And second, you look at the job title code. The petitioner's pay stubs as STDM levels 2 and 3 have title code 909A. The official list has 9094, which is STDM level 1. And I'd like to just point out, Your Honors, how fundamentally illogical the petitioner's position in this litigation is, because petitioners concede that the SSMs who changed into STDM levels 2 and 3 in 2012 went from a non-physically taxing role and retained their non-physically taxing status. What their position is, the people that were promoted into STDM levels 2 and 3 somehow gained physically taxing status that people that were reclassified in 2012 don't have. So they're arguing that people that do the same jobs, which is primarily supervisory, that have the same job and the same job title code, have different classification. And it doesn't make sense. They've never explained how that could possibly make sense. It doesn't make sense. These are jobs that are not physically taxing. They never were. They were never on the official list, and they were never removed from the official list.
Thank you.
Thank you.
The city's position denies the existence of Tier 6 of the pension system. Every employee now being appointed to 90904 who had not been under Tier 4 is in Tier 6. So they are not, although serving in a physically taxing title, eligible for the early retirement benefits that were available to the person next to them who was appointed before 2012 and was in Tier 4. This is not just happening with the STDMs. Throughout the city, any physically taxing title is now being personneled by, I don't want to use the word
What
manned,
does that
but
have to do, though, with how we interpret the reclassification? It almost seems like apples and oranges.
I'm sorry, Your Honor.
Don't worry about it, forget about it.
But
Thank
the
you.
point also that the city
Your
tries to
time's-
make,
Your time's up, thank you.
well, just the union was not even aware of the use of 909A beyond the payroll until employees had gotten their letters from NYSERS, in some cases 10 or 15 years after serving as STDMs.
Thank you.
Thank you.
People versus Huggins.
Good afternoon. May it please the court, Matthew Bova for Mr. Huggins. The prosecution has conceded that under the Court of Appeals decision in People versus Williams, the Fry hearing below was erroneous. The Fry hearing decision below was erroneous.
Let me ask you the most basic question, but it's, to me, a very compelling question. Why isn't any issue about the DNA harmless error, particularly in light of the fact that as to one of the two incidents, there wasn't even any DNA evidence used? So clearly it didn't affect that case. In the other case, there was a lot of other overwhelming evidence, including surveillance videos, which supported the conviction in this matter.
So so just to divvy it up, as to the November 3rd conviction, which is where the DNA evidence was specifically linked, it linked to Mr. Huggins' pocket to the tune of 332,000 to 1. Once that devastating, conclusive statistical evidence came in at trial, it was game over for the defense. The government had other evidence.
Counsel, if that was the case, every time we found that there was an error in DNA evidence, we would be reversing, and that's not the case. There are definitely instances where I've been on a panel where I've found that an error as to DNA was not reversible error because it was harmless error. So normally we look at the quality of the other evidence in the case and an overall assessment of the case to make that determination. There's no per se that if DNA evidence was wrongfully brought in, that's reversible error that can't be subject to the harmless error analysis.
Yes, Your Honor, but the DNA evidence in this case
Why was it so devastating in this case in light of all the other evidence?
because the surveillance footage is blurry, does not permit an identification beyond a reasonable doubt. Perhaps you can look at that footage, and it's here on.
Didn't two people identify this defendant, though, just based on the photograph, the wanted photograph that was created from the surveillance footage?
Including the defendant himself.
All he said was that picture
Right,
resembles.
but two other people identified the defendant from the photo, which was created from the surveillance photo.
Well, an officer concluded that he believed there was probable cause based on a resemblance, but the complainants themselves, they don't make an identification when they look at the
Right,
wanted.
but this is not overwhelming that they didn't, where two people did. Anyway, go ahead.
So the blurry footage, all we can say when we look at that is it could be him. We can't say that as Crimmins requires. It's the
What
kind
about
of
all the clothing that matched up, that there were distinctive items of clothing that were found, other than the hat, that were found in this locker and matched up to what was in the surveillance footage?
the clothing again is generic. We have a white shirt, we have black shoes with a white bottom. This is the kind of clothing that, again, maybe it's evidence for the prosecution, but it's not evidence that conclusively establishes guilt beyond a reasonable doubt. What the evidence in this case shows,
You're looking at the evidence piecemeal, right? But when you look at it in the totality, you have the clothing, you have the video with 2 out of the 3 judges that are involved here said was pretty clear. And then you have the cell site information. You have the defendant himself saying that it resembles him. when you put all that together, that's overwhelming, isn't it?
No, it's not overwhelming. It's
And
a
add to
good.
that the cell phone evidence, which showed him by the
Cell
site.
towers.
Yeah, cell towers. I'm sorry. You
The
said-
cell tower evidence just puts him near the scene, near the vicinity, along with thousands of other New Yorkers.
Right, again, if you look at it independently, I agree with you. If you look at just the cell tower information alone, it's not devastating. But when you put it together with everything else, it forms a nice puzzle.
I think it forms an interesting argument for a jury. But it's not overwhelming evidence. It's not the kind of evidence that we can look at this and we could say, no matter what, we can conclusively and with certainty conclude that if we excise the 332,000 LR, this jury most certainly would have convicted.
What impact about the 15 loci that was tested and his DNA was found on that, does that matter at all in terms of this overwhelming evidence that we have?
No, because without the statistic, the statistic is the whole ballgame here. Without the statistic, all they can say is, well, it could be him. He cannot be excluded. He is consistent with the mixture. The reason why we require statistics here is because the scientific community has recognized that throwing a whole bunch of alleles to the jury and saying he's consistent with them does not actually prove anything, because that could be thousands, if not millions of people who have those alleles. It's only the 332,000 LR that converts he could be there into devastating, damning evidence of guilt. And that's exactly what the prosecution's own expert testifies to. She doesn't say, oh, I found that this was very strong support for guilt because all of his alleles are there. She says, as OCME has been doing for a decade now, she says, I found very strong support because of the 332,000 LR. It's the statistic, not a general ambiguous conclusion about, well, he cannot be excluded. That is critical here. And the rest of the evidence, it paints an interesting argument for the jury. The government may have had a decent argument for the jury. They may have gotten a conviction. They probably wouldn't have, but that's not enough. It's not enough to have sufficient evidence.
Can you address your request for a sentence reduction or to run the sentences concurrent?
Yes. At a minimum, the court should reduce the sentences and run them concurrent, which would produce a sentence of 20 to life, which would allow for Mr. Huggins right now, who's serving a 38 to life.
Is that appropriate in light of the circumstances here, right? We have a defendant that, I guess the jury believed that he stalked two witnesses, two victims, followed them from the ATM into the vestibule. These are older, frail people that should be protected in society. He assaults both of them, taking their property, and he did this after serving a pretty long prison sentence. He's released 5 months, and here he goes at it again.
So 20 to life is a very serious sentence, and it addresses that serious harm.
But 20 to life that's really punishing him for one crime, right? There are two victims here. What do you say to the second victim? It's like, well, he has victim number one, so he's entitled to victim number two, and he gets the same sentence?
But the reality is that a 20 to life sentence would allow for Mr. Huggins to have a little bit of life left if he's eligible for, if he's found to be released for parole.
Thank you.
But the current sentence puts him in prison for the rest of his life.
Thank you.
Thank you.
Good afternoon, Your Honors, and may it please the court, Samuel Goldfein on behalf of the people.
I think. What do you say to the proposition that DNA evidence, I guess, can be viewed by the average layperson, the juror, as something that's exceedingly powerful? And if you have this evidence that you now concede should not have been introduced, that's saying this 332,000 figure, how can we be sure that the jury would have convicted him anyway, absent that evidence?
For a couple of reasons, Your Honor. First of all, I admit DNA evidence is powerful. We wouldn't have tried to introduce it at trial if we didn't think it was powerful. We think it was powerful. It certainly pales in comparison to the other evidence at this trial. Defendant was caught on surveillance video, committing the crimes, stalking the victims from the bank, attacking them, stealing their money, injuring them in the process. On top of that, when the police showed defendant a still image from the surveillance video, he agreed that it resembled him. And more importantly, when the officers told defendant that they were going to search his locker for the clothing that the perpetrator was wearing on the videos, defendant said they wouldn't find one specific hat, a tacit admission that they would find everything else. And when they went and searched his locker, they did find everything else. Those articles of clothing are distinctive and in combination lent powerful support to the jury's conclusion that defendant was the person on the video. On top of that, the jury had cell phone photos of defendant wearing those same articles of clothing, so they could compare his build, his facial features, his complexion, and his attire to the person on the video to conclude that it was the same person. And as Your Honor pointed out, 2 officers recognized defendant from this image, and so did defendant himself. On top of that, there's the cell site evidence, there's the MoneyGram, there's the refusing consciousness of guilt evidence where he refuses to participate in the lineup, and he lies about being employed, he lies about sending the MoneyGram, to his niece, as well as the non-FST DNA evidence that put all of his alleles at the 15 loci tested such that he could not be excluded as a contributor. In light of all of that evidence, it's impossible that the jury would have acquitted but for the statistic at the end of the FST calculation. And even in the prosecutor's summation, he did not focus on the DNA evidence hardly at all, and the FST evidence was a passing thought. It was really focused on all this other compelling, photographic proof of defendant's identity as the perpetrator. I would turn very briefly to the sentence. I think it would be
38 to life, counsel.
Yes.
That
it's a long sentence.
It's a lot.
Absolutely.
Shouldn't that be reserved for? And I'm not minimizing what happened here at all, but shouldn't that be reserved for murders, for rapes, for
I agree that it's a long sentence, Your Honor. The legislature has determined that for someone like defendant here who is a persistent recidivist, there are steep mandatory minimums, and the minimum for just his crime against Mr. Schaefer is 20 to life. I think it would be manifestly unfair and unjust for a defendant to receive no punishment whatsoever for the crime he committed against Mr. Albert. If there are no other questions, I know there's a lot of other points in the brief. I would rest on the record and ask that you affirm. Thank you very much.
Thank you.
This is just not the stuff that a harmless error finding is made of. This is equivocal circumstantial evidence. It pales in comparison to the conclusive damning effect of the DNA evidence. A MoneyGram telegram, that's what we're talking about here. Sending $50 several hours after the November 23rd robbery to someone's niece. Sending $50 to your niece does not establish that you stole it. This is weak evidence at best. Refusing a lineup. That is exactly what the jury could have easily found an innocent person would do, because an innocent person might say to themselves, I'm rolling the dice here with this lineup if I participate. I want to wait for counsel. Mr. Huggins had asked for counsel. The police had refused.
Counsel, I understand that as you go through it one by one, as my colleague pointed out, maybe, yes, but when you put all of those things together, and then you have this one issue of the statistic, but you have everything else, the consciousness of guilt, the $50, which is coincidentally what was taken from the individual, the cell phone tower, the identifications. You can't just look at them individually in a vacuum. Like if you look at the totality, why isn't that harmless?
Well, first of all, Your Honor, it wasn't just $50. It was $500 taken. So therefore, that argument just all that indicates is someone sent money to their family member. Yes, there are several strands of equivocal evidence here. What does that add up to? It adds up to a decent case to a jury, but it doesn't add up to harmless error. It doesn't add up to overwhelming evidence. In almost
Would your argument be stronger if there was faulty DNA evidence with respect to both victims as opposed to only one?
Well, the November 3rd conviction should be reversed because it wasn't harmless as to that conviction. Then there's a very clear spillover argument as to November 23rd. People versus Morales instructs that we just look to whether there's a reasonable possibility that the jury's conviction on the tainted count impacts the next count, the spillover count. And here, there is such a reasonable possibility because of the similarities of the offenses. Thank you.
Thank you. Wallach versus New York City Health and Hospital.
Good afternoon, Your Honors. May it please the Court. Jeff Kerfman on behalf of the appellant. Supreme Court erred first in concluding that Wallach showed merit to his disparate impact claim, and second in finding that the certification factors favor class litigation. This Court may and should reverse on either ground. First, Wallach cannot show merit to his claim because even the figures he cites show there is no disparate impact at most of the acute care facilities.
No, this is a favorable question to you, but how can we even analyze those figures where they don't break out the acute care facilities? How are we to make an analysis of whether or not there is or is not a disparate impact? And were figures ever prepared just about I'm sort of confused how the acute care facilities got broken away from everything else.
I completely agree with Your Honor. That's the first among many defects with the analysis at issue here. The analysis included figures that covered both acute and non-acute care facilities. That it wasn't broken out in the
So how
spreadsheet.
can we possibly, I mean, I know this question is in your favor, but how can we possibly analyze this issue then without a breakdown between the different facilities?
Your Honor, I would argue that you can't conduct that analysis, that's an analysis that should have been conducted based on information developed during discovery and presented to the trial court in the first
At
instance.
what point did that come out, the idea of breaking out the acute care facilities? Did that come out during the oral argument, or was that something argued in advance by plaintiff's counsel?
Your Honor, that did not come out. The question of whether to certify a class based only on the acute care facilities did not come out until full briefing after the second motion for class certification on oral argument. It was not briefed. It was raised at oral argument for the first time, and the judge chose to certify a class on that basis without having had any briefing on that topic. But I would emphasize, Your Honors, even if the court were to look at these, at the figures that Wallach relies on, he still failed to show a disparate impact based on those figures because reductions at 6 of the 11 acute care facilities favored or came as close as mathematically possible to favoring employees who were over 40 years old. There's no reason to look at these facilities in the aggregate because CEOs exercised broad discretion in determining which positions to eliminate, which employees to retain for those positions.
Did HHC have final say as to who remained and as to who had to be let go?
The HHC gave broad discretion to the CEOs to identify which employees would remain in the positions that remained. HHC conducted a final level of review to determine, first a legal review, to determine whether there were disparities based on protected characteristics and in certain unquantified circumstances, there were requests from HHC to review reduction determinations. But there's no evidence in the record that any CEO corrected a decision based on HHC's guidance, and certainly no evidence as to how many times that occurred.
It was guidance geared towards an ultimate plan, an ultimate more uniform structure, right?
The guidance which was described in the testimony as soft guidance was geared towards a more uniform structure across across HHC's facilities, but it was not guidance to the CEOs telling them which positions to maintain and how even to make that determination.
But the overall policy was we need this to be accomplished, right? The reduction.
Certainly, there was a policy geared towards an overall reduction, but in making that, in determining which positions would remain and which positions would be eliminated, broad discretion was left to the CEOs to make those determinations, and those are the determinations that would have influenced whether employees who are older than 40 or under 40 remained in the organization.
Are there any arguments, I know we've been touching around it, but are there any more general arguments you want to make about the lack of a common mode of discretion with respect to class action certification, since we've been touching at the edges of it all?
Certainly, Your Honor. I think the broadest point is that Wallach's entire argument rests on a set of loose guidance materials, a table of organization, and a flowchart that contains entirely generic considerations for the CEOs, such as whether a position can remain or not, or to consider whether an employee is a fit for that position. But there was
the focus wasn't on certain employees being eliminated. It was just eliminating positions, the best positions possible to create efficiency.
Exactly, Your Honor. And if I may, beyond the faultiness of the figures and that Wallach relies on and his theory of common control, another glaring problem with his case, even at this stage, is that he failed to make out any showing that there was a statistically significant disparity as is expressly required under the city human rights law. Statistical significance has a plain meaning, as we've laid out in our brief, and that definition is not the same as the 4/5 test that Wallach has exclusively relied on in these proceedings. The Federal Code of Regulations and the case law is clear that these are not the same concepts. They're not substitutes for one another. And regardless of what suffices under federal law, the CHRL refers only to statistical significance.
We don't even know what the numbers are in the first instance to make that kind of determination, do we?
I agree, Your Honor.
I mean, like, it doesn't even break out who is retired versus who moved to another position, which would be an essential item we need to know to do a disparity analysis.
I completely agree, and as a general proposition, the idea of this court at this stage conducting a disparate impact analysis 7 years into this litigation, 2 motions for class certification later, it does not comport with the way this litigation should have proceeded.
Thank you.
Thank you.
Good afternoon. My name is Michael Taubenfeld, and I represent Mr. Wallach, the respondent.
Let me ask you about the disparate impact first. Why don't we start with that? Because how can you establish a disparate impact where, again, at a very base level, the statistics don't even break down between acute care facilities and other facilities and people who were let go versus people who were put in other positions at other facilities? How can we possibly even make that initial determination of what the impact exactly was?
Well, so in terms of whether people were let go or transferred, our position is that if people were transferred, that's an adverse employment action.
They might have liked that transfer. We don't know that.
No, so
Because we don't have the individual, that would be another individual determination arguing against class certification, because some people might have been thrilled with the transfer they got. We don't know that it's an adverse unless someone's speaking up and saying it was adverse to me.
No, so inherently a transfer to a different position is considered an adverse employment action.
It was a promotion. Anyway, talk about the first one, which is even more major, which is that the statistics you've provided don't break down between acute care facilities and other facilities.
So there is a breakdown in the record. The spreadsheets that we rely on do have a breakdown between the different facilities. This wasn't an issue, obviously. We do agree that this wasn't an issue that was raised in terms of breaking down the class for acute versus non-acute until oral argument. If it's necessary, we certainly would be happy to submit a supplemental letter just explaining what the breakdown is based on.
Again, as counsel, your co-counsel pointed out, it would be hard for us to make that analysis in the first instance here on something that's not even in the record, which is what you seem to do.
Well, it is in the record. The data comes from the record. It's just that the
Right, I meant supplementary letters that are not before the record below. But anyway, go ahead.
Right. So I think that the key point to remember in this case is where we are. We're not on the motion for summary judgment. A lot of the arguments that my adversary is making is an argument that the merits, essentially, they're going to lose on the merits if this case continues. We're going to lose on summary judgment.
Right, but you need to have a disparate impact as a part of your prima facie. But let's go to the requirements for class certification. And it seems like one of the core requirements for class certification in these type of cases is a common mode of discretion. And certainly a strong argument can be made why a common mode of discretion was not used here, where each agency got to use their own procedures and how they were going to make these decisions, and it wasn't uniform from up above. What's your best argument as to why there was a common mode of discretion?
So it's important to understand the background. There were 2 steps to this process, 2 phases. There was MEI phase 1, which HHC implemented in order to cut down on costs, and they realized they gave way too much discretion to each individual facility. So they decided, what we're going to do now is we're going to come up with a system that constrains discretion. We're going to provide this table of organization. It's a table that lists the different positions and the different layers of positions that we want each facility to have. We're going to provide them with flowcharts and data, and we're going to do reviews, and we're going to make sure that the people who are being terminated are the people who we essentially feel should fall within that rubric. There is my adversary refers to this as loose guidance, and all the instructions that were given is obvious. Everyone knew what was going to happen anyways. It's not true. There's an actual flow chart and a spreadsheet in the record which requires each individual hospital to come up with a total score for each individual person they're considering terminating.
But isn't Isn't it undisputed that each one was given the ability to make the decision in their own ways? There was no uniform procedure in place as to how they were going about making these decisions?
We acknowledge that HHC didn't pick specific people, but that's not what has to happen here if there to be a common motive.
What were their exact instructions to each individual facility in terms of how to pick which positions to eliminate?
They gave each facility a table of organization, which listed the types of positions they wanted to see after phase 2 is over. They gave each facility documents with flowcharts and spreadsheets saying, list all of your people, list all their job duties, and follow this flowchart to figure out what score to assign to each person. Then once you pick the people you want to pick, send them to us, and we're going to have a conversation, and we're going to go over and potentially reject the people that you've chosen. And once that process is over, HHC would then approve, which they had the sole discretion to do, the terminations that the facilities chose. We're not denying that there was discretion, but a common mode of discretion requires by its very nature that there be some discretion. Otherwise, it's not a common mode of discretion. We don't need to show for disparate impact that HHC picked each individual person to be terminated. So essentially, just to go through it, in phase 2, HHC provided the facility with the headcount targets. They provided specifically with the table of organization, the categories of individuals that or positions they wanted in order to remain at the end of the process. They explicitly told each facility, you can't pick union employees, you can't make decisions based on performance, disciplinary issues, attendance. None of that can come in. This does not fall within the discretion that you have. I think it's also important to point out that given that we're...
Any of that goes, though, to a disparate impact claim. None of those factors have to do with over 40, under 40.
I'm sorry.
None of those factors have to do with who the people are.
But that's the point that we're making, is that the discretion that each facility had was very limited based on all of these limitations that HHC put on them. HHC essentially was saying, you can't consider these factors, these people, you have to look at these specific factors, eliminate these specific types of positions.
Thank
That's
you.
ultimately how decisions were made.
Just 3 points, if I may, Your Honor. First, in terms of employees who were let go versus transferred, there's no indication in this spreadsheet whether this employee maintained the same salary, what exactly happened. So, and the bottom line is Supreme Court certified a class of employees who were terminated, not employees who experienced an adverse employment action. Second, in terms of the merits, even though this court has applied a lower threshold on the merits, a core statutory requirement under the statute plaintiffs use to bring suit is a showing of statistical significance. They have not made any attempt to satisfy that basic statutory element. And third, in terms of commonality and the class certification factors, I would just reiterate that there were, of course, guidance materials provided to the CEOs, but these were, the considerations in these materials were entirely generic. They were decide whether you, based on your local understanding, can keep this position. And I would emphasize no CEO was ever deposed to understand the process that they followed in this reduction series. We'd ask that the court reverse. Thank you.
Thank you. Thorograph versus NYRA Racing Association.
May it please the court, Norm Cerullo for plaintiff appellant Thorograph. We're here today for two reasons. The court below had committed reversible error, again, at least with respect to two independent reasons.
Let me ask you a specific question just to start. How are you going to grapple with a very well-established legal principle that an implied covenant cannot serve to negate the express provisions of an agreement, where here the agreement explicitly permits either party on sufficient notice to terminate the agreement? So if we were to allow an implied covenant claim to go forward, it would seem to negate that express provision which allows a party to terminate for any reason.
Yeah, I think it's appellant's position is actually to the contrary, and that is there is an implied covenant of good faith and fair dealing implied in every contract.
We know that, but there's also a very well-established principle that if there's an express provision in agreement controlling something, you can't get around that by trying to create an implied covenant where the agreement specifically does not allow for that. So here, the agreement could not be more clear that you can terminate for any reason whatsoever as long as you give the required notice. So how would finding an implied covenant in this situation not negate that express provision?
Well, I think the case law, including case law from this first department, is clear that even when there's a discretionary right in a contract, that discretionary right still has to be exercised in good faith, or conversely.
Right, but when it says any reason, that means any reason.
Well, the contract does not say for any reason. It's a termination for convenience clause, right? And so the question is, does a termination for convenience clause create a carve-out to the implied covenant of good faith and fair dealing that exists in every contract? Our position is no, it does not. And in fact, the case law is very clear on that, including the case law.
Counsel, I mean, just the language of the termination for convenience clause, it excludes any language for good cause shown or for any reason. It just says that any party may terminate. So if you're looking just at the plain language of this particular, which was negotiated or, you know, agreed upon by the parties who entered into this particular agreement, it says they may terminate it. It doesn't give any qualification.
Look, and I think that the case law is clear on this, including the Rick Ball case out of this court, which specifically said that even when there is an expression, an explicit discretionary right, including where contractual provision provides sole discretion to a contracting party, that even those provisions have to be exercised in good faith, and they can't be exercised in bad faith to preclude a contracting party's right from the ability to take advantage or to have the benefit of the bargain in those particular
Obviously, a very limited exception would swallow the rule, which is a very black letter rule that you can't negate an express provision by finding an implied covenant, and that's black letter law. So if your suggestion is that every time you could just go and look at other factors, and what would be left of that rule?
Well, look, I think it depends on what the claim is, right? The claim here is not breach of contract, or there is a breach of contract, but up on appeal here is not a breach of contract claim. It's a breach of the implied covenant of good faith and fair dealing.
Because you can't make a breach of contract claim because the contract allows them to terminate. That's the only reason you don't have a breach of contract claim.
Well, we do have a breach of contract with respect to other provisions of the
Right,
contract.
but with respect to the termination, you can't have a breach of contract because they're allowed to terminate under the.
Well, that's the sort of the crux of a good faith and fair dealing claim, is that there is not a per se breach of the contract, and we're not alleging that with respect to the termination clause. Well,
Right, but aren't there a legion of cases which say that when there's an express, we're going in circles, when there's an express provision, you can't use that. It's when it's not somehow addressed within the terms of the contract, it somehow goes beyond the terms of the contract that you're allowed to do an implied covenant.
Yes, so I think there's case law on this, and certainly respondents in the court below has not cited a single case in which a termination for convenience clause has been allowed to negate the good faith and fair dealing.
In terms of what you're seeking for the termination of the convenience clause, it would be the non-payment or the fact that you're entitled to certain payments that weren't made. Is that correct?
That's the crux of our breach of contract claim, is that NYRA has withheld substantial sums of money to Thorograph.
Right, but in terms of the covenant of good faith and fair dealing, what is it that you're alleging was the harm that was caused by that?
Yeah, so the allegation is that NYRA, when presented with evidence from Thorograph that they were withholding monies, held up the termination clause, the termination for convenience clause, as a sword to coerce NYRA to give up its rights under the contract. And so this wasn't a situation where the termination for convenience clause, frankly, it's there so that parties don't have to look for cause to terminate agreements, but it's not there to be wielded as a weapon here by NYRA to be able to terminate the contract.
But it wasn't used as a threat because they actually terminated the contract. I could see if, well, we were being extorted because we have this valuable contract and they were holding this sword over our neck, but they actually lopped your head off. They terminated the contract, so it wasn't a threat. They followed through with it, good, bad, or otherwise.
Sure, it was a threat, and they carried through on it. And part of the breach of the covenant in good faith and fair dealing is that this part may not be a direct per se breach, but here you have a situation which NYRA is bringing in millions of dollars in revenues, which in turn reduces its need for public subsidies. So it's hurting the public fisc and lops off the head, as Your Honor had said,
Thank you.
For spite.
Thank you.
Thank you.
Good afternoon, Your Honors. If it please the court, Matthew Hurdy on behalf of defendants, respondents.
Well, counsel, what do we make of that? I mean, just in terms of the sequence of events of how the termination was actually executed, that, you know, there was an issue about monies and whether or not the payments were being made in the way that the contract needed them to be, or detailed that they should be, and then said, well, you know what, we're going to terminate. Why isn't that bad faith?
Because the contract's explicit language gave my clients the explicit permission to do that, Your Honor. The termination for convenience provision was negotiated by both parties, and under the clear law of New York, as it's been since A.S. Ramble in 1957, when there's a provision like that, any party can exercise it, and no cause of action arises from exercising it. That's why it's not bad faith.
I mean, but we do have case law that does say that where, you know, termination for convenience clauses are invoked for illegitimate purpose or in bad faith. It's not something that's absolute, right? We can look at to see, well, what was the impetus behind it? Like, why did you go into this termination? There's case law out there that says that.
I'm sorry if I misunderstand, Your Honor. I'm unaware of any case law that says anything but it is an absolute right. As a matter of fact, you know, the evolution of this rule started in 1957 with the Court of Appeals of the State of New York in A.S. Ramble saying where the parties have agreed to a termination clause, the clause is enforced as written. After that, in 1994, this court, in the Big Apple car case, said it was an absolute rule, Your Honor. Allow me to quote this court's decision from Big Apple in 1994. A party has an absolute, unqualified right to terminate a contract on notice pursuant to an unconditional termination clause without court inquiry into whether the termination was activated by an ulterior motive. Absolute unqualified right, Your Honor. That's what this court has said over and over again. In 1994 in Big Apple, this court said it again in 2003 in Triton Partners. The exact quote that I just read to you, the court said it again in 2003. The court said it again in Red Apple Child in 2003.
I'm sorry, sir. Does that mean that this is some sort of exception to the body of law that your friend invoked, that an explicitly discretionary contract right cannot be exercised in bad faith? Are these cases an exception to that more general rule?
Or I
Because
guess,
go ahead.
or I guess more recently decided by this court in 2023, where it says that, you know, that right might not be exercised solely for the personal gain or in a way to deprive the other party of the fruits of the contract. So, I mean, like I said, I understand that we have a huge body of law that does indicate that, but there's something behind the fact that you can't, as your adversary indicates, as a sword in the same way.
I understand what Your Honor is saying. What is the case that Your Honor is citing, if I may ask?
The tycoon case. But you don't get to ask me questions, but it's the tycoon case.
I don't know if I'm not familiar with that case, Your Honor. I don't know if it's addressing a termination for convenience clause. I would address the other question asked. I don't think of it as an exception. It's a logical result of the breach of the covenant of good faith and fair dealing and the clear law in New York that we enforce the explicit, clear language of an agreement. When the parties negotiate for very simple language, a very simple mechanism, as we have here now, parties are allowed to exercise it, and the courts don't interfere with the parties' expression of their clear intent. And so there is no more benefit to the bargain than what is embodied in the termination for convenience provision. The termination for convenience provision defines the scope of the benefit. And so
I guess your friend's point would be, because the termination for convenience clause doesn't indicate that it can be done for any reason, that the general good faith and fair dealing covenant can be grafted onto that provision. Now, you know, if for instance the clause said any party may terminate this contract for any reason whatsoever, well, then implying the pledge that he's seeking to have embraced by the covenant of good faith and fair dealing would be expressly inconsistent with that kind of contractual language.
Your Honor, the courts in the state of New York have said that when you have an unadorned, unconditional termination for convenience provision, such as we have here, it is taken to mean termination may be effected for any reason. That's in the case law, Your Honor, and that's in our briefs. That is simply the law. The cases that hold, as Mr. Cerullo is citing, that a provision of a contract cannot be used as a purposeful scheme to deprive the other party of the benefits, those cases don't involve a termination for convenience provision. Rich Bell does not involve a termination for convenience provision. That is a fact-heavy case involving much more complicated scheming on the part of the defendant. All the cases are very clear that we've cited in our briefs that apply to the provisions here, and there's simply no quarreling with 70 years of clear law.
Thank you.
Thank you.
Your Honors, I'd like to pick up on a question that one of you had raised as to whether or not the cases that Mr. Hurdy is citing and relying on are exceptions in some way. And in my view, they're not. It does take a very careful, detailed review, a lot of this case law, but a lot of the cases, particularly the ones that Mr. Hurdy is relying on, that respondents are relying on, are very fact-specific. Many of them do not involve breach of the implied covenant and good faith and fair dealing claims. Many of them involve breach of contract claims. Many of them don't involve termination for convenience clauses, which is its own term of art with its own body of cases. Many of them deal with different contractual provisions that allow for parties to, in their sole discretion, take certain acts. I think actually a case that respondents relied upon is somewhat helpful. It's the A.J. Temple case out of the Second Department. And there's a case where the Second Department actually sustained the dismissal of a implied covenant and breach of implied covenant and fair dealing case on summary judgment. And that is because the plaintiff completely conceded there was no allegations as to bad faith, and a review of the underlying trial court case found that there were no such allegations in that case.
Thank you.
Thank you. Thank you, judges.
YC versus City of New York.
Good afternoon, Your Honors, and may it please the Court. Vanessa Neal, Herman Law, for Plaintiff Appellant. Plaintiff Appellant requests that this Court reverse the lower court's decision dismissing defendant CCSI from the amended complaint. There are two provisions of the CPLR that permit plaintiff to have a cause of action against CCSI, CPLR 203 and CPLR 1024. Turning first to CPLR 203, in order to have the cause of action relate back to the newly added defendant, plaintiff would have to show that the parties are united at first.
Let me ask you, there's many elements of united interest, but one of them is that they have some type of agency relationship, and you argue that there is an agency relationship between the city and Catholic Charities. What evidence is there in the record at all that supports a claim of an agency relationship between these two parties?
Yes, Your Honor, and right now at the pleading stages, it's the allegations within the...
I'm sorry, what allegations are there that support?
Yes, Your Honor. So in the amended complaint, plaintiff does allege vicarious liability through the non-delegable duties that the City of New York held when they contracted with CCSI for the placement of plaintiff into the White Foster Home. Through that non-delegable duty, the City of New York remained liable for the negligent actions of CCSI. Accordingly, City of New York is vicariously liable for CCSI's actions, and they are united in interest through this agency relationship. Going back to same transactions and occurrence, both the complaint and the amended complaint arise from sexual abuse that was endured in 1973 to 1974.
Let me ask you, not saying that I agree with that analysis you just gave, but let's say you're correct that there is an agency relationship. One of the other things you have to show is that they have the same unity of interest. how can you show the unity of interest in this case? Don't they have different defenses that each of them would be asserting if the case were allowed to go forward against both of them?
Well, Your Honor, and defendant respondent brings this up in their brief, so I will point to that now. The major defense that defendant respondent points to is sovereign immunity, governmental immunity that could be brought up by the City of New York. And as I'm sure Your Honors are aware, that is currently on appeal with the Court of Appeals. Weisbrod-Moore was just argued in the beginning of January. There's yet to be a decision. So pending that decision would really depend whether or not there is a separate defense. It is plaintiff appellant's position that there is not a separate defense because there was a special duty owed to plaintiff by virtue of being a foster child. Again, I am aware of the QG decision in this court and Weisbrod-Moore in the Fourth Department, which is now before the Court of Appeals. So, and we do request this within the papers as well, is that if that is something that Your Honors are considering within United in Interest, that Your Honors wait or determine based on Weisbrod-Moore in the Court of Appeals.
Okay, putting that aside, what about prejudice? Considering this is a 50-year-old case, prejudice, which is another one of the factors to be considered in relation to.
Yes, Your Honor. And so when the complaint was filed in 2021 and named the City of New York and at the time New York Foundling, it was then amended in May of 2022 to amend defendant CCSI. There's no reason to believe that any evidence that was available in 2021 would not have been available in 2022. Also, at the time that plaintiff had amended to add in CCSI, discovery had not taken place, there were no depositions, and while this is beyond the record, we are still within the same fact pattern.
Could you address the element 3 of CPLR 203F, the mistaken omission?
Yes, Your Honors. So when plaintiff had originally filed the complaint, she was under the good faith belief that New York Foundling had placed her, and in fact, New York Foundling had placed her in a subsequent placement. However, at the time of the original complaint, plaintiff had no reason to believe that New York Foundling was not the original placement agency. And we'll get to this in the 1024 argument, but plaintiff did indeed send letters and tried to ensure that she had the correct parties.
Let's combine the two because we're running out of time and the other ground is 1024 and they sort of overlap in some degree. But there was a 7-month, I believe it was a 7-month gap between the time that the attorneys first found out that there was a mistake when they actually brought leave to bring in Catholic Charities. How can that be excused, that 7-month gap in this circumstance where due diligence is one of the main requirements under CPLR 1024?
Sure, Your Honor. So going to 1024, we focus in on the due diligence, the reasonable due diligence prior to the expiration of the statute of limitations. So while 7 months may have lapsed from finding out that New York Foundling may not be—
But at that point, you're already so late, you already knew at that point, there's no defense that you weren't aware, and you still didn't act expeditiously in terms of bringing Catholic Charities in.
Yes, Your Honor. So during that time period, plaintiff appellant was investigating to see who the proper entity was and going about filing through their investigation. But going to your point in terms of 1024.
Why couldn't all this been done? I mean, there's a lot of ways to do investigation in these cases. There's FOIL requests before the case starts. There's pre-action disclosure. There's numerous things that can be done to ascertain the correct defendants, none of which were done in this case in a timely fashion.
May I respond, Your Honor? To your point, in regard to 1024, I would just like to point the court to the DiMarzo case, which is cited by the defendant respondent, in which the court held that the plaintiff who did not send out FOIL requests as you did, whereas we did, as you note, we sent a letter request akin to a FOIL request. Days prior in the DiMarzo case, the appellant had Google searched, essentially, the Doe defendant, and that was enough for the court to determine that that was reasonable due diligence. There's not an extraordinary due diligence requirement. It is just reasonable, Your Honors. Thank you.
Good afternoon, Your Honors, and may it please the court. My name is James Wise. I'm an associate at Traub, Lieberman, Strauss, and Shrewsbury, LLP. And my office represents the respondent defendant, Catholic Charities of Staten Island.
Let's start with the same question. Why wasn't there an agency relationship between the city and Catholic Charities?
Well, firstly, Catholic Charities of Staten Island has no records pertaining to plaintiff's residency in the Weeks home. Secondly, the allegation that an agency relationship existed is based on mere speculation. The record is devoid of any reference to what New York Foundling's attorneys advised plaintiff's attorneys that led them to believe that CCSI was involved in plaintiff's placement in the Weeks home. There's nothing in the record that details what, if anything, plaintiff did to verify that position. And in fact, in her affirmation in support of her motion to amend, plaintiff does not say or aver that she was placed in the Weeks home by Catholic Charities of Staten Island.
Go ahead.
I would also like to add that the court was correct the lower court rather was correct in holding that the city and Catholic Charities of Staten Island lack a unity of interest, given the divergent interests between the two defendants in this case. I'll direct the court to Conlon v. Hayden, which posits that defendants cannot be held united in interest if one can seek to avoid liability by shifting the blame to the other. Here, should CCSI be added to this case, it will move, or rather, it will assert that the city is solely liable, especially given the fact that plaintiff reported her allegations of abuse to her social worker, who was presumably a Bureau of Child Welfare employee. And the city will likely attempt to do the same, as evidenced in their answer of asserting affirmative defenses against New York Foundling.
Well, how do you answer your friend's argument that the city had a non-delegable duty to supervise the foster care, and so that it nevertheless did delegate that to CCIS? Doesn't change the fact it was a non-delegable duty.
I would say that there's nothing in the record to support that, and that is based on mere suspicion and under Regina v. Broadway Bronx Medical Center, Motel Co., mere suspicions and conjecture are insufficient to establish a unity of interest. Again, there's nothing in the record to establish that our client was in an agency relationship with the city.
Would your client have the same type of defenses as the city had?
No. The city, regardless of the merits of its argument, the city believes it immune from this case based on a governmental function or a professional judgment. CCSI is not a municipal entity and therefore cannot assert the same defense, and will instead, if added to this case, propose that the city is solely culpable for the misconduct here, especially given the fact that it does not have any records pertaining to plaintiff's residency in the Weeks home.
Thank you.
Thank you.
Thank you, Your Honors. I would just like to address 2 points by opposing counsel. First, in terms of presumably the social worker being a city employee, as mentioned in our reply brief and through the course of dealing in these cases, it actually has seemed as though within the contract between the city agencies and the placement agencies, the social worker is actually more likely than not a social worker by CCSI. Therefore, it would not have necessarily been a city social worker. Again, discovery would reveal that. And in terms of the united in interest argument that defendant respondent brings up, I would like to refer this court to the Bernero case, in which the city of New York argued that they were not liable for a employee who had committed a tort of negligence within Central Park. And in that court, in that case, this department had held that the city would be vicariously liable for the conservative's negligence through a contractual indemnification, which would arguably be a different defense than what the conservatory had. So even if there was an indemnification agreement, which is what the city raises in the affirmative defense, they could still be and they are still vicariously liable for CCSI. Thank you, Your Honors.
Success Academy versus Liberty Square Realty.
May it please the court. Henry Masha, attorney for the appellant, Liberty Square Realty. Supreme Court should have reversed for two reasons. First, the cause of action for a declaration that Success Academy can terminate should have been dismissed. And second, Liberty should be granted use and occupancy. Regarding termination, I have 2 points. The first is that the lease does not provide for termination based on just an ordinary uncured breach of contract. Section 31.1 says the lease cannot be terminated except...
Counsel, in terms of the use and occupancy argument, when did Success Academy start occupying the space?
Well, they were given access as of December 1st, 2017. And Success has said that they have, decided not to take up what they believe the landlord failed to do, and so they have not physically been occupying.
They were given access. That's at the time that they had the fence with the padlock?
As of December 1st, 2017, they had access to it. And while they say...
Padlock?
There's no question, well, assuming in the sake of the truth of the allegations in the complaint about the fence and the
Simple
padlock.
yes or no, did they have a fence with a padlock?
Well, we're going to assume that that's true for the sake of this appeal because it's a pleading motion. But even if it did, Success's actions speak louder than those allegations because the record is clear that they accessed the property multiple times when that fence was supposedly there and locked.
Was there a film company that was conducting some kind of film on the premises? Was that Success Academy that allowed that, or are there allegations that that was not Success Academy?
The allegations are that that was Liberty, but those all occurred after January 1st, 2018. So at the very worst, that's a disruption of the quiet use of enjoyment. It doesn't go to vacant possession. Success Academy had vacant possession as of December 1st, 2017. There's a letter in the record at page 615 turning that over, and
They rejected that letter, correct?
that's right. They rejected it because they said that the landlord's work was not finished. They didn't say anything about having possession. And then,
Well, they said it was uninhabitable. If it's uninhabitable, they can't take possession if it's not in a habitable condition. I mean, is your argument that even though, assuming it's true what they're saying, that the building was not habitable, that they're still forced to take possession?
absolutely.
Okay, well, let's go back to what you were talking earlier, because you were making an argument about 31.1, which says it precludes termination for certain reasons, but it says except as provided elsewhere in the lease. So nothing in that provision prevents you from looking at other provisions in the lease.
That's right.
So let's look at why doesn't section 1.3 and 37.1, which require the landlord to use its best efforts to complete the landlord's work in a good and workmanlike manner, conforming to all legal requirements, why aren't those sections a separate obligation, which imposes an obligation on the landlord to complete the work, the breach of which would give rise to a cause of action for breach and allow termination?
Well, we're not saying that it doesn't give them any cause of action. We're just saying that
Why
even
would
if there's
that
a
allow
breach,
termination if they didn't perform the work in a good and workmanlike manner, which then made the premises uninhabitable, giving rise to constructive eviction? Why wouldn't all those things be enough, which are all alleged, to constitute grounds for terminating the lease?
because section 1.3 doesn't say that the violation of that provision leads to termination. It provides another remedy. It says that if the repairs aren't done to the satisfaction of Success, they can make repairs and charge the landlord. That's what the parties agreed to. And that's, by the way, a common theme throughout the lease. That's true in section 1.3. It's also true in section 3.4b, where if the landlord's work wasn't complete, Success Academy gets a reduced rent, and they get to take up the work and charge the landlord. That's consistent throughout.
They tried to do that, and that did not work out. You resisted that. Your client resisted the remedy of them going in to take over the work and resisted. So why would it be unreasonable to construe the lease to read it in a complete and harmonious manner that the landlord's breach of its obligation to do the work in a good and workmanlike manner prevented the tenancy from ever taking tenancy, and therefore the tenancy never went into valid effect?
Because the only way to read the lease together as a harmonious whole is to read 31.1 as the default, which says it has to be specifically
but 31.1
provided.
doesn't say what you're saying it says. It does provide specific examples of what would constitute grounds for termination, but it doesn't, it says the contrary, that there's no other grounds for termination. It says, except as provided elsewhere in the lease.
Right.
So there's nothing in that section that says these are the only grounds for termination, and none of the other provisions of the lease constitute grounds for termination, or does it?
It uses the word specifically provided. And that's important because the only place that specifically provides for termination is section 3.4C, which is about the failure to give vacant possession by a certain date. That's the only one.
Then doesn't
Well,
that read out section 3.7, which says in the event this lease is terminated by A, B, or C, only one of which, subdivision A, is 3.4?
It doesn't, and I'll tell you why. There's a couple reasons. First, let's look at the point of 3.7. That's to tell you what happens after a termination. It's not meant to enumerate all the grounds of termination, and that's embedded in the text of the lease because it says in the event that it's conditional. So in order to know what you have to do, whether and under what circumstances success can terminate, you have to look elsewhere in the lease. And guess what? The lease tells us exactly what happens when the landlord, quote, defaults. And that's in section 32.1C. And that says if the landlord, and it tracks the language of 3.7B, it says if the landlord fails to fulfill its obligations under the lease, then success can give a notice to cure, and if that default is not cured, there's a specific remedy.
Thank you.
Success gets to take up the work.
Yeah, have time on rebuttal.
Good afternoon, Your Honors. Robert Weigel from Gibson, Dunn & Crutcher for Success Academy. Your Honor's point is exactly right. If you look at 3.7 of the lease, it says expressly, in the event this lease is terminated, A, pursuant to 3.4 above, which is vacant possession. And my friend wants to, I guess, try the vacant possession question in front of Your Honors, but we have alleged and that there was a fence, there was a padlock, we never got possession. They rented this place out. Apparently, it's somewhat spooky, and if you're doing a vampire movie in the
Put
Bronx.
aside the padlock, though, because that was a temporary position in the film crew. Is your position that that because the space is unusable, you haven't been delivered vacant possession, your client?
Absolutely, Your Honor. There was.
And what's your support?
I mean, we weren't given any possession, first off, because we weren't allowed access, but we also were sort of constructively evicted. They were obliged to do this. This was going to be a school, and they were obliged to build this to code and to use their best efforts to do that. We have an elevator that's too small because you've got to be able to put a gurney into it, and they didn't do that. The electrical wasn't up to code. The main stairway where the students were going to come down had uneven stairs that they did not fix.
Then why isn't the remedy, as your friend indicates, that to go in and then you complete the work, not necessarily to terminate?
Well, Your Honor, I would direct your attention to 3.7 A and B. They would read B out of the lease. B says, in the event the lease is terminated by reason of landlord's default in the performance of its obligations under the lease.
And one of those obligations back in 1.3 was to substantially complete the work.
One of their obligations was to do the work in a good and workmanlike fashion.
And
Under
then
their theory,
you make allegations that on November 30th, 2017, although your adversary indicates on December 1st you were able to take possession, but on November 30th, that work hadn't been completed, right?
the work was never completed. It's not completed today. They didn't have any money is the real problem here. They had $323 in the bank. They committed to us to do $17 million worth of work to turn this into a high school for the Success Academy. Has a lot of students in the Bronx. They didn't have a high school in the Bronx, so they wanted to have a high school in the Bronx. They gave them $2 million, which they promptly spent instead of putting it into an escrow account as they were supposed to. And they've never done the work. They didn't have the money to do $17 million of work. They had no financing. They had no bank account. They didn't do what they were supposed to do. Under their theory, they could have handed us the keys the day after the lease, not done anything, and said, well, you have to pay rent for 20 years. because they really didn't do anything. They didn't do anything constructive. We're going to have to rip out, if we ever were to take possession of it, what they did, because it's not up to code. And there's no record of what they built. That's all in the complaint. There's no as-built plans. So 31 does not have the same, 31.1 does not have the absolute meaning that they would like to attest to it. In addition to that line in the front, up at the top where it says, and except as otherwise specifically provided herein, if you go down to about 2/3 of the way down, it says additional rent and all of the charges and sums payable by tenant hereunder shall continue to be payable in all events unless the obligation to pay the same shall be terminated pursuant to the express provisions of this lease. It's plural. It's not just vacant possession. If you read this lease and you read 3.7 and you give effect to all of the language in 3.7, this is a 3211 motion. They have to utterly refute, because they're trying to do it based on the lease, our allegations, and I would submit that they have not, and that the Supreme Court was correct. Thank you.
Thank you.
This is really a case of tenant has buyer's remorse. They miscalculated how much they needed to spend to do their part of the work, and that's why they're trying to get out of this lease. Let's go back to 3.7. We're not trying to read 3.7 out of the lease at all. We want it to be read as it's written, and it's written in the conditional. It says, in the event that the lease is terminated on certain grounds. So in order to know, and one of them is by reason of the landlord's default in the performance of its obligations. So to know when termination applies to the landlord's default, you have to go to the rest of the lease. And the rest of the lease tells us exactly what happens in that circumstance, and termination is not one of the remedies.
So
32.1.
Which lease provision would be covered by B?
It's our view that there aren't any lease provisions that could be covered by B.
So would that be a commercially unreasonable interpretation of the lease?
Not at all. The contrary would be commercially unreasonable, because 3.7b would be an exception that swallows the rule. Remember, this is a 20-year net lease where the tenant gets to customize the interior of the building to fit its specific needs as a school, which reduces the marketability after the lease is done. So that's why after they get vacant possession, they can't terminate. If they have all of these horrible things that you heard from my adversary that we did, if they can prove them, they have a remedy. They can take up the work, they can do it themselves, and they can charge the landlord for it. That's what the parties agreed to. The fact that the tenant doesn't like that agreement anymore is not a reason to terminate.
Thank you. Kirby versus David Fabricators.
Good afternoon, Your Honors. Elisa Colums on behalf of Appellant David Fabricators. To distill it down, plaintiff already litigated this action to conclusion in Illinois, despite having information that David Fabricators allegedly supplied transite baking decks that in part caused Mr. Kirby's exposure to asbestos to defendant Baker's Pride in the Illinois action. Plaintiff failed to sue David Fabricators.
Does that mean that they waive somehow now instituting a lawsuit against you?
Well, I would say, under Illinois law, you are required to sue all necessary parties. While it's true that plaintiff need not sue all joint tortfeasors in one action, there are exceptions in both the common law and statutory authority. So our argument here is that Baker's Pride is a necessary party to this action.
Well, one of the primary arguments you're making is that you're giving up the ability to have liability apportioned if they're not here, but that's not the law in New York. The law in New York allows apportionment even when another party's not present, and nothing prevents you from making whatever argument you want to make at trial that another party is liable rather than you. So I'm not sure, without that apportionment argument, I'm not sure why there's still a necessary party, since the law, there is law in New York that joint tortfeasors are not necessary parties.
Sure, so generally, Article 16 does allow you to do that, but there is a jurisdictional bar that if the claimant could not obtain jurisdiction over the party against which you want to introduce that evidence, then that evidence can't be introduced. This was just addressed.
You don't get, isn't that one of the factors for necessary, how to go forward once it's determined that someone is a necessary party?
Right, exactly.
But we're talking about whether they are a necessary party in the first instance. We're not talking about whether those factors are satisfied. First, we have to show that they're a necessary party.
Correct, and here they
So
are.
what, again, since the law clearly says joint tortfeasors are not necessary parties, how do you get around that?
So here, Baker's Pride dictated every single detail of the baking decks at issue, including the material at issue, the size, etc. David Fabricators' near entire defense is premised on the actions and the decisions that Baker's Pride made.
What's preventing you? I mean, is there still potential liability as a supplier? No matter whether or not the fault was 99.9% someone else, you can't get dismissal of the case just based on the fact of supply, because the law doesn't support that kind of argument. So that being the case, what is preventing you from making any of those arguments you wish to make at trial? I mean, people do that all the time. They make arguments, especially in asbestos cases, against the parties that aren't present. So especially without them there to defend yourself, you have even more ability to make those arguments as to why they're responsible and you're not.
Correct. So our argument is that CPLR 1601 has an important proviso that unless the claimant proves it could not obtain jurisdiction over the non-party, you cannot introduce evidence as to that joint tortfeasor. Here, all of the exposure, as it concerns Mr. Kirby, occurred outside of New York State. There is nothing in the long-arm statute that would confer jurisdiction on Baker's Pride. And further, I mean, the Illinois court, per the Illinois Joint Tortfeasor Contribution Act, also discharged Baker's Pride from any contribution liability.
That doesn't go to jurisdiction, though. That may be a merits issue, but that's not jurisdiction. So
Sure,
has someone established that there's either subject matter or personal jurisdiction under R to B lacking as to Baker's Pride?
Right. And that is what our papers argue, that jurisdiction is lacking as to Baker's Pride. It's not a New York corporation. All exposure took place outside of New York State. Claimant would not be able to exercise personal jurisdiction over Baker's Pride.
This is interesting because normally it's the plaintiff who makes this argument.
Right.
Right? Not the defendant. The defendant's Article 16 is set up this way. It's your right in the first instance to point the finger at the non-party.
Right.
The burden falls on the plaintiff unless plaintiff can show there's no jurisdiction over the non-party.
Right. But that is our argument, that at trial, that is how we will be limited in presenting evidence as to this party that dictated every single decision that David Fabricators made in this action. There is no jurisdiction.
Back to Justice Kern's question earlier.
Sure.
So under CPLR 1001A, that defines who is a necessary party.
Correct.
And so you need to join a party where that party's presence is necessary to afford complete relief between the parties in the action. Baker's Pride isn't necessary to adjudicate the rights vis-a-vis you and plaintiff. You want them there for your own purposes, but it's not necessary to have them there to render a full judgment between the two parties we have now.
Sure. I mean, I would say, the policy of, 1001A discourages multiplicity of actions, and that's here. While, could they try this case solely against David Fabricators? Sure. But in terms of accurate, complete resolution of the issues without this giant piece missing, we argue that that's simply not possible. I would argue that the other factors of CPLR 1001 are amply fulfilled. Whether plaintiff has an effective remedy, yes, they recovered substantial settlements in Illinois, including from Baker's Pride as to the exact product at issue. B3 asked how this prejudice could have been avoided and by whom, and certainly that was plaintiff here who had the information as to David Fabricators in Illinois and refused to sue them. I will cede the podium and I'll wrap up in rebuttal.
Good afternoon, Your Honors. Josh McMahon for the respondent. May it please the court. CPLR 1001A talks about what a necessary party is. The case law is clear that joint tortfeasors aren't necessary parties. So we don't get to 1001B, the 5 factors set forth therein. Even if we did, however, we would argue that those factors weigh in favor of permitting the action to proceed in the absence of Baker's pride. We detail that in our papers. The primary argument that David Fabricators raises is this prejudice claim based on Article 16 of the CPLR. 1601 sub 1 doesn't preclude them from introducing evidence of Baker's pride's liability. It may speak to the culpable conduct and whether or not that can be included in apportionment or the equitable share, but it certainly doesn't preclude them from introducing evidence thereof. Therefore, their prejudice argument.
Well, they might get apportionment anyway under 15108, right?
Correct, Your Honor. So we would argue that there's no prejudice. And furthermore, even if they were somehow precluded from introducing evidence of Baker's pride's liability, CPLR 1601 sub 2 talks about how there's this interplay between the Article 16 and General Obligations Law 15-108, wherein David Fabricators would be permitted to reduce any verdict awarded against them by the amount set forth in the settlement, which is the entire reason why they're claiming prejudice in the first place. I would argue the other four of the 5 factors also don't apply. I think the prejudice one is kind of the main one. With regard to res judicata, briefly, res judicata only bars additional actions between the same parties based on the same claims, based on the same harm. There is no identity of parties here. Plaintiff, as David Fabricators itself points out, never asserted claims against David Fabricators in the plaintiff never asserted claims against David Fabricators in the Illinois action. And as this court instructed in Rojas, whereas here the parties are litigating a claim against each other for the first time, res judicata does not apply. If the court has any other questions, I'd be happy to address them, but otherwise I will cede my time.
Thank you.
Just briefly, I would just direct the court to the patent case, which came out in October of 2024, which this near identical issue was examined in New York County, and the successive suit was thrown out due to the prejudice that is to befall the defendant due to its inability to put on its Article 16 case. In terms of General Obligations Law 15108, we don't dispute that we'd be able to get a set off. It's really the evidentiary issue here that we are concerned about.
Why, I'm still confused, why are you precluded from introducing evidence at trial as to Baker's pride role in the making of these ovens?
I mean, this has been addressed before. I mean, I know in our papers, the Snowdale case, Judge Leibovitz banned evidence against, I believe it was Babcock and Wilcox, because the exposure took place in Connecticut and Babcock and Wilcox was not a New York company. Here we have the same kind of thing. We have a non-New York company, out-of-state exposure, and Article 16 will operate to ban evidence. That's how it's played out in the courts. And I mean, in terms of res judicata, we could be here for 3 more hours, but I would rest on my papers in that regard.
Gigowsky versus Mount Sinai.
May it please the court, Frank Winnick, Amity Demerson McManus for Mount Sinai, the appellant respondent. I'd like to focus on the reply brief that plaintiff filed, which is the last word on their motion, and there are things there that I think that I should bring to the court's attention that are not accurate and raise issues of fact that should defeat their motion for summary judgment. So the plaintiff says that the accident happened outside of the trauma room in a corridor adjacent to the trauma room. That's their plaintiff reply, page 1. Well, plaintiff testified that the accident happened, quote, right over the threshold of the door, close quote, quote, right at the door of the rapid response room, close quote. And so what's important to note is in their case, they would like to have a set of facts that are not true, but which they would like to be true, but are inconsistent with the record. The next one was they said that there was no patient in the rapid recovery room when the plaintiff entered, and therefore it should have been spotless. Well, plaintiff testified that there was another patient in the room and that medical personnel were treating the patient at the time, and that's at 119 to 120 of the record. And since the recovery room was not empty and cleaned, there would be no swept pile of wipes. Where did the accident happen? In which way? Did the accident happen on the way out of the recovery room or on the way into the recovery room? Well, the plaintiff said that it happened coming out of the recovery room, and his EMT partner said that it happened on the way into the rapid recovery room. One of the differences, and that's at 216 of the record. One of the differences is that if the plaintiff is facing forward, which is what his partner testified to, then he has a clear view of the floor in front of him. And therefore, assuming for the moment that there was a pile of wipes there, then he would have the ability to see it. That doesn't negate a possible liability verdict for Mount Sinai on negligent maintenance, but what it does do is it preserves the affirmative defenses of comparative negligence and potentially open and obvious. The plaintiff reply, page 9, says that Mount Sinai could not produce a witness to say, quote, no pile of wipes, close quote. But Mount Sinai produced affidavits from 2 housekeepers that were on duty that day that said neither man saw an EMT slip, trip, or fall outside the recovery room, and neither man saw a pile of disinfectant wipes.
Are you still pursuing your claim for summary judgment? Because it doesn't, you haven't addressed it all, that's why I'm asking. And if you are, then I'll ask you a question about that. Because everything so far has been about opposing the cross motion for summary judgment.
Well, to me, that's very important because then if I argue my motion and spend my time doing that, I think that there are facts that may indeed defeat my motion for summary judgment.
I understand. Your main argument really is that neither side's entitled to summary judgment, that there are factual issues that should go to trial in this action.
Right.
Is that correct?
Yes, but in my brief, I did discuss a way in which I think that Mount Sinai would be entitled to summary judgment, and I would rest on what I wrote in the brief. Obviously, if the court asks questions, I will answer them, but what I wanted to do was to point out that they're not entitled to summary judgment on liability, and they're not entitled to dismissal of our affirmative defenses, because that, to me, is the greater loss. Plaintiff said that someone, maybe a maintenance man, told him to clean up the wipes. And in the 2 affidavits that were submitted by the Mount Sinai employees, they said that neither man told anyone to discard a pile of wipes. And so, with regard to issues of fact, even though the plaintiff was the only one to testify as to exactly what happened, that there is permitted to be and should be a trial where the credibility of the plaintiff needs to be tested. And if there are so many occasions on which his testimony has been countered, then we should have the opportunity at trial to address them. And that's why it's been important for me to address these issues. And finally, plaintiff says that Ms. Aronoff, his partner, got a wet floor sign. Now, Aronoff testified that the first time that she was told about the bleach wipes was back in the ambulance. So regardless of whether she remembers about doing a yellow caution sign or not, there would be no reason for her to have moved a yellow caution sign if the first time that she found out about an alleged condition on the floor was in the ambulance. So again, another issue to test plaintiff's credibility on. Other things that in the reply brief, which again, obviously is the last word unless I say something here, plaintiff relies on Gale versus City for the plaintiff's burden of proof on a motion for summary judgment. However, Gale concerned a jury verdict, so.
I'll let you address the rest of it on rebuttal, okay?
Yes.
Good afternoon. I'm Stephen Chaquin, and it looks like I'm going to be the last words that you hear before you recess for the day, so I'll try to make the words as pleasant as I can. I take the argument that you just heard as an implicit concession that he's not entitled to summary judgment, and I think under the normal standards that's correct. The case that he's trying to put together is full of factual questions and not full of evidence to support his side of them. So that would have to be decided by a jury from his point of view. My case is very different. The best way to understand my case is to assume correctly that this part of the emergency room complex is like a laboratory. It's like a sealed environment. It's not like an ordinary emergency room where anybody can come in, anybody can go out, anybody can drop anything anywhere. Nobody gets into there.
Why isn't it just a question of fact based on the fact that the coworker testified that she didn't see anything at any time? He testified, when he testified that it happened on his way out, he testified that he didn't see anything was coming in. And he's contradictory about whether it happened when it came in and came out. Why aren't those issues alone enough to raise issues of fact? And the housekeeping claims that they cleaned everything up and that they didn't see anything on the floor. Why isn't all of that enough to raise issues of fact?
Well, let me try to convince you. The housekeepers, one housekeeper has no idea when he inspected. He says we inspected it, or he said it was inspected. He can't tell us when. The other housekeeper said, I inspected it at the beginning of the shift, which was 3 p.m. Now, Mr.
They also
Gynagras,
testified that they routinely cleaned up in between each incident that was occurring. They went in and cleaned everything up.
right, but according to my friend here, there was no time between the time that Mr. Gynagowski appeared, helped get the patient onto the bed, left the trauma room, and had his incident when there wasn't any patient in that room. Certainly, there couldn't be anybody cleaning up.
Right, but if they cleaned up before the last patient and the new patient was just coming to the room, that supports that it was clean.
Yeah, except the hospital argues that they had overlapping patients. And my client's testimony is that when he got there, there was a patient there. So they didn't have a chance to do that. But more importantly, the whole thing is this controlled environment. Nobody can go in there except people who are permitted. And those are doctors, patients, nurses, and the occasional EMS person. Okay? Nobody could bring anything in there because that's who was there.
This is your causing argument, right? That there's no question they caused it? What about if it didn't even exist, since your client's the only one who claims that he even saw these wipes? No one else is acknowledging that there were ever any wipes on the floor. So even if it's this cause argument you're making, why isn't it an issue of fact as to whether the wipes even were ever on the floor?
Well, I mean, that's not an odd position to hear, but I think that
Not an opposition to hear?
No, an odd position to hear. That's an expected response from a court on that. But if that's really the law, then doesn't that mean that nobody who has an unwitnessed accident can get summary judgment?
No, it depends if there's contradictory evidence.
But there's no contradictory evidence
The
here,
coworker says she never saw anything.
right? That's an absence of evidence. That's not evidence of absence.
But she didn't see him fall either. She didn't see him fall either.
No, she saw him sort of stumble and catch himself, which is what he said. He thinks maybe his knee hit the ground. It doesn't matter. Because, and you know this from my brief, that we have cases that say, if you're trying to prevent yourself from falling and you injure yourself in that process, that's an accident, a compensable incident. I think I should stop now.
Thank you. You'll also have time to rebuttal if you wish.
Yes, thank you.
Thank you, Your Honors. I would just go back to the unwitnessed accident cannot be granted summary judgment, and I know the court just addressed it. And of course, I agree, and I would go back to the instances that I raised in my main argument of all the factual issues that are raised with regard to the plaintiff's credibility that needs to be determined at trial. And with regard to the sanitary wipes, there is not ipso facto liability just because sanitary wipes are used only in the rapid response room. What happens is that the wipes there are indeed, used to what there need to be done, which is to clean up what's going on and things like that, and whether they're thrown or anything else. And the other patient that was in the room was having a heart attack, and the plaintiff had even described the nurse as running around like crazy because they were having problems. And so the only thing my last sentence is that the wipes merely furnish the condition or occasion for the accident rather than one of its causes.
Thank you.
Okay, let me start with, now I get to correct him. The patient who was having the heart attack was the patient that our EMS people were bringing in. So he wasn't already somebody else there having a heart attack. We have no idea what was going on with the other patient, neither does the record. So that's nothing. So also with Ms. Aronoff, she was asked a very specific question. Do you remember getting a yellow sign? I have a whole footnote devoted to the 6,000 things she didn't remember from this date. So that she doesn't remember getting a sign doesn't mean that there wasn't a wet floor. So it's just another thing, because it was years between the time that this happened and the time that she was deposed. You don't expect her to remember as much as you'd hope she would. So we're back in a closed environment where the hospital controls everything. Yeah, the hospital wipes, the hospital setting, everybody is there because the hospital wants them to be there or allows them to be there. There's no doubt unless Mr. Gigowsky has decided to make up the whole thing, and that's not what EMS people do. They don't go and get treated for knee injuries afterward that don't exist and so on. They were there. He fell on them.
Thank you.
Yeah, thank you.
Thank you.
All right, thanks for your attention.
All right, Stephen?
So nice to
Good
get
luck
meet
to
in
you,
person.
yes.
Well, thank you. Good luck to you, too, except on the case.
Yes. I always say good luck to my adversaries because I have no control over what the court decides.